All right. This should do. Okay, a very simple structure to walk you through the Council of Europe and the European Union. I think it's good to talk about both Europes, and this is what I'm trying to do, at least in the second half of the presentation. I'm going to sort of compare both approaches, the one being a soft law approach. I won't dwell upon the importance of soft power or normative power or soft norms versus the EU, which is shifting to a harder law system. I'll try to sort of clarify the position of both bodies first, because there are some limitations to what they can do, some specificities of the one versus the other, which are, I think, worth mentioning, after which I will, in a doctrinal fashion, try to walk you through the core components of the policies of both institutions, touching upon the scope, material scope, personal scope of the system, the reporting system, which in both instances is like three-channeled, a three-tiered model, follow-up and feedback, and protection measures and support measures. To start off with the Council of Europe, as Fabio already mentioned and elaborately mentioned, the entire context in which the topic is phrased at Council of Europe level is one about transparency, accountability, integrity, and sort of whistleblowing is part of this organizational ethos of integrity, which links in with corruption, which links in with data protection also. We've discussed about protection of the personal data, including the identity and confidentiality around it. So important axes of the Council of Europe policy are the right to data protection, is Article 8 of the Convention. We also have a more detailed convention, Convention 108, which has been modernized last year. In addition, it's good to mention the civil and criminal law, corruption framework, and the Groupe des États contre la corruption, the peer evaluation body of the Council of Europe in that respect. But the core component, even if it may be contested by some as being an important component, we need to recognize that Europe, that is 47 countries at least at Council of Europe level, but also again the EU officially embraces freedom of expression as a core component of a whistleblowing regulation. At Council of Europe level, this was less stressed by Fabio, but the source protection at journalist level and the freedom of expression also of the journalists and the media and the press is, I think, even more important at Council of Europe level than at EU level. The jurisprudence around Article 10 is elaborate, and the most important ruling that we've had, or judgment, a Grand Chamber judgment of 2008, which was mentioned as a source of what the Luxembourg court also tested, were the 6 criteria put forward for the first time officially in this judgment. As you can see at the bottom of the slide, this is sort of a stable framework that is being used by the Strasbourg court. So it's been reiterated in several other cases over time. So it's fair to say it's a stable assessment based on the 6 criteria. I think it's pointless to walk you through the 6 criteria again. Fabio has properly done that in testing it out in the 2 columns. I don't know which slide it was, probably 4th or something. So well done. If you want any further explanation, I'm happy to go into that. But it's good to understand that what the court does is test in which circumstances an interference with the right to freedom of expression is acceptable because necessary in a democratic society. And in that case law, that has been tested precisely for information leaked by a whistleblower having the right to freedom of expression and being confronted, of course, with limitations to that right, because there may be sanctions or there may be retaliation, etc., or there may be disclosure, non-disclosure rules. Is that all acceptable? That is what the court tests and necessary in a democratic society, because there should be no limitations unless necessary. And this tiered test is typical, I think. In addition to that, I need to be honest and open to you that this is not always stable. As you see on, I think, the next slide, I extend this to jurisprudence in the field of journalists and the right of journalists to protect their sources. In many cases, it shows that this right of journalists to shield the sources actually shows the need to protect the leaking of information by whistleblowers. And there's also a bulk of judgments of the Strasbourg courts which can be mentioned there. It's also an overview over time. It's fixed and stable jurisprudence. There's a couple of judgments that have been receiving a lot of criticism, because in these, the court took a slightly or a significant differential position vis-à-vis what it normally does in doing the 6-tiered test. And there's 3 examples which are worth mentioning: Pascoe versus Russia, Langer versus Germany, and Karapetian and others versus Armenia. Starting off with the first, and we're immediately touching upon a difficult area. It was a journalist, but a military journalist also being part of the military, who had disclosed classified information and was charged with treason. And the court doing the test says that basically it's okay to punish him. He got off with only 4 years, which is extremely lenient, the Strasbourg court said. So in testing the severity of the sanction there, actually the balance shifts to, we need to give scope to states to still charge for treason. It could have been way worse. He had military capacity and so forth. So the outcome is not always that there cannot be an interference. Another case, a more simple case at municipal level, a simple accusation by a civil servant about alleged perversion of justice by a deputy mayor, which eventually turned out to be unfounded, even if probably done in good faith, didn't convince the court that there was an interference with the right under Article 10. So it's not, the framework doesn't perfectly work. Neither did it in the last case mentioned, which was not even referred to the Grand Chamber, even if there was a call to do so. It was about dismissal of civil servants, having disclosed alleged fraud of election process in Armenia. In that case, the court ruled there is a clear interference with the freedom of expression, but I do not conclude that there is a violation of Article 10. It's very frustrating, especially for all the scholars who look into media freedom, etc. This case law is sort of irritating because it's not going far enough. I'm not a specialist in freedom of information, but it's, I think, fair to conclude that notwithstanding that we have Guya versus Armenia, and that it's quite stable, the test that the court does, usually with proper results, that we can have unexpected results. So it doesn't perfectly work. It doesn't sufficiently shape the clarity that probably we need and want, especially not when we enter into very difficult spheres having to do with national interests or military or defense or classified information. Okay, that's a very tricky area, and actually my presentation will document and show that neither the Council of Europe nor the EU will actually solve that because it becomes too difficult. We would have the same with people opposing the system or dissidents to the government, etc. That usually is left to the national discretion of states to deal with. The legal instruments, I don't know to which extent the slides will be circulated, but for the ones interested, I've also hyperlinked the documents. If the PowerPoint will be circulated, it's handy to get access immediately Very quickly, I won't, there's two bodies mentioned there. The first one is the Parliamentary Assembly of the Council of Europe, is the Parliament of the Council of Europe, and the second, CM, is the Committee of Ministers. It's the two most important bodies at Council of Europe level. So the first two lines are about parliamentary documents, resolutions, and recommendations. The second one, I think, is of particular importance because it's specifically about whistleblowing in the context of national security and access to information. After that, I will immediately talk about the content of it. After that, in 2014, the Council of Europe adopted its most important soft instrument, the recommendation on whistleblowing, 2014-7. John has mentioned it this morning with the 29 principles. It's a key, important document. If I will compare immediately the Council of Europe with the EU, my main instrument at Council of Europe level will be Recommendation 2014-7, this one. That's why I marked it in red. This is the key instrument, the Council of Europe level. Even if there's more instruments, like the other one, 2015-5, is not bad, it's not uninteresting. It's sectorial, of course, in a context of employment, where it's sketched that where employers implement internal reporting mechanisms, the confidentiality of whistleblowers should be ensured, also the protection of personal data. So you see each time the importance of personal data of all parties involved, not only of the whistleblower. It's also an important element. And what is also, I think, relevant is that this one in particular says that there would only exceptionally be scope for anonymous reporting. We've heard about protection of identities and confidentialities or anonymity. It's not the same, okay? Confidentiality about identity is one thing. Anonymous reporting is when people are allowed to anonymously report without disclosing their identity. Okay, it's very different, the situation. Especially in terms of the rights of the other party, the party which is probably affected by the whistleblowing. If that party needs to have a fair trial in the end, you need to have sort of a counterbalance, which is going to be very difficult if reporting was fully anonymous. So here it's actually discouraged. Only extremely exceptionally would be allowed here. Then, last slide for the Council of Europe. This parliamentary resolution, again, the one on top, calls on all Council of Europe member states, it's a strong statement, the 47, to grant asylum to whistleblowers, including in government agencies or at the level of private contractors who work with the intelligence services, whose disclosures are in line with previous resolutions of the Parliament and of the Tshwane principles. South Africa, Tshwane, the area around Pretoria, I think. We had this very important document, the 50 Global Principles on National Security and the right to information. I've provided the hyperlinks, also a summary in 15 points. It's a key document of reference which is being embraced and has been embraced by the Parliamentary Assembly of the Council of Europe. To do what? To call upon its member states to actually provide whistleblowing, including in the context of government officials in spheres of defense, intelligence, and national security, which is the no-go zone most of the time, right? We've also seen that in the case law of the Strasbourg Court, that in principle, when it's about classified info and military secrets, basically it's okay for the state to protect these. Here the Parliament wants to go further. So far unsuccessfully, the Parliament has, on top of that, called upon the Council of Ministers to initiate the conclusion of a hard law Council of Europe text, a convention, including this sort of officials. You see at the bottom of the slide that the Council of Ministers is, not very surprisingly, sort of reticent to do so. It says, well, we have adopted quite recently, 2014, our major recommendation, the 29 principles, and one of the principles touches upon information in that very sphere. So we think we've done enough so far, okay? But we'll see in a minute what actually the principle is about. That touches upon the military and defense sphere. Actually, it's an exception. It's accepted under the principles that basically we shouldn't protect whistleblowers there and that we can sanction them. That's what the principles say. So the Council of Ministers, a more political body, is not very keen to follow up on what the Parliament recommends. As far as the EU is concerned, and I'm moving ahead, it's of course builds upon everything that the Council of Europe does. So if it officially says in its policy, we of course adhere to the freedom of expression. The EU has its own fundamental rights document, which is the Fundamental Rights Charter. Article 11 of that is the corresponding article of Article 10 of the European Convention on Human Rights. We also embrace and describe the jurisprudence of the court in Strasbourg. Obviously, we do support the soft law instrument of the Council of Europe, Recommendation 24/7, and we have our own two articles in the Fundamental Rights Charter, Article 7 and 8, the right to data protection. Then what happened, and it was briefly explained by Fabio already, we had this process going on at EU level. Since the Lisbon Treaty, most of the competencies actually are being dealt with under a co-decision procedure between the Parliament on the one hand and the Council on the other hand, upon a proposal of the European Commission. So the Commission comes and tables a text. This is what happened. The Commission has first come with a communication and a work program in 2017. The Parliament has adopted a resolution, as you see, even spontaneously, which doesn't happen quite often. This committee, Jury Committee, is one of the subcommittees of the European Parliament on legal affairs. It's adopted a spontaneous report calling for a horizontal legislative proposal before the end of 2017. Horizontal meaning the Parliament says, EU ministers, please do adopt a horizontal scheme working across sectors for everything. Commission said, hold on, I will check whether that's doable. Probably we'll go for an extended sectoral approach instead of a horizontal approach. And actually this is what happened in the end. The Commission has proposed a directive on whistleblowing. It's sectorial, so it doesn't follow up actually on this recommendation of the Parliament to go for a horizontal approach. Provisional agreement was reached, Fabio, in March, correctly, but later on the Parliament has officially voted, 16 April. And when I was preparing last week, Thursday morning, the official version was released, 25 September, so it's the most recent text. It's the so-called P-Cons documents of the Parliament and the Council, so the adopted texts, and I think within 2 weeks we'll have it in the official journal, after which it will be binding upon member states to be transposed within 2 years. Now, the material scope for the Council of Europe, let me be quick. There is in the explanatory memorandum a shopping list of all sorts of behaviors that could be included under the material scope, but the Council of Europe officially chooses and deliberately chooses not to define the scope of information that falls within the definition of public interest. It's about public interest disclosures, and the Council of Europe says, based on former King of Greece and others versus Greece, the states are best placed to decide what is in the public interest, period. But in point 1.2, in fine, it is stated, one of the principles, principle 1, that in principle it should include violations of law and human rights, as well as risks to public health and safety and to the environment. For the rest, a lot of suggestions. So material scope, open, but ideally at least violations of law, human rights, health and safety. The linkage to human rights is typical for the Council of Europe. We don't have it as such at EU level in the directive. This may also link in with, I don't know whether you know the framework of human rights defenders at UN level and the special rapporteur and the mandate of the special rapporteur of the UN for human rights defenders. There's even specific resolutions adopted by the International Conference of Data Protection and Privacy Commissioners who say that human rights defenders should not be controlled in internet context and should be able to like freely voice their messages, should not be hindered, etc. So there's an entire UN body of soft law around human rights disclosures, and I think it's important that the Council of Europe stresses this. At EU level, a long list of sectors, and I think it's a good job. There's a 20-page annex with all EU instruments which are relevant. This is binding law for the member states in all these spheres, so it's massive. It includes also offenses and violations which have an impact on the negative impact on the budget of the EU, the so-called PIF crimes. And also other breaches to internal markets, including the spheres of competition, corporate tax and pre-tax arrangements, of course, and state aid. So there's a lot of scope for fraud in all these sectors. Everything relating to health and nuclear health and animals and welfare is in principle included. Human rights in general, not. Why? It's not a specific sector, right? And is the EU competent to come up with a horizontal approach? I'm afraid it doesn't have the competence either. Is it allowed to introduce norms in the sphere of national security? No, national security is a non-competence area of the EU, right? So it's not to sort of diminish the importance of it. I think it's probably at its maximum as far as the EU is concerned. And the striking, interesting bit is that privacy and personal data disclosures are in. So the Snowdens who disclose mass surveillance, this is protected, and it's human rights, okay? It's fundamental rights. How come? It's probably the only human rights domain which was sort of embedded as a sectoral approach. It's the human rights lobby within the EU. We have it embraced as a sector itself. That's why it features in the list. Personally, it sort of frustrates me that where the EU could have done more, like in the area of discrimination or gender discrimination or racism, where it also has adopted binding legislation, that we don't have it there. So is it useful in Me Too contexts and abuse on the work floor? Unfortunately not, and it could have been the case. Very strict chair. Material scope, national security. Difficult area, as I said. The Council of Europe says, and this is the rule referred to by the Committee of Ministers, a special scheme is allowed including modified rights and obligations in that sphere. So basically, the recommendation is important, the other 28 principles, but hey, you can come with exceptions in this sphere. The same actually for the EU, but EU is very open about it. It's at least, we should say, is very clear. The EU says national security is member state area, period. It's also like that. And there's also an exemption for classified info at national level and EU level. So it's simply exempted. So we have a binding directive, but not in these areas. I'm sorry. The EU is insufficiently competent because the member states didn't want to give in power. The personal scope, nothing spectacular. Public-private is sort of common. It's mainstream in the meantime. The circle of persons, Fabio, luckily we had you because I don't need to repeat it. So it's a wide circle and it's quite impressive if you read the detail. What I find relevant to mention is that the protection offered in the EU directive, read Article 4.4, is also extended to facilitators, third persons, colleagues and relatives, etc. So if a relative of you, if there would be retaliation measures against anyone very indirectly, it's also prohibited. So it comes with a very elaborate list of persons who are eligible as a whistleblower, but the protection offered is even much wider. And it's a remarkable difference with the Council of Europe soft instrument. before, during, after, not only when you're on the job, it was already said by Fabio, pre-contractual arrangement, solicitation procedures, also if you left the job. So it's basically before, during, after. And the Council of Europe and the EU are on the same page. The EU is more elaborate in sort of writing it down the way it should be done. The three-channel reporting. I need to say something about it, because the Council of Europe is sort of hesitant as when it comes to the hierarchy or possible hierarchy between both. Because we have had jurisprudence of the court in Strasbourg about journalists who say that journalists who actually may disclose information that was leaked to them by a whistleblower who had not first internally blown the whistle may have made a professional mistake. So that there's probably indirect rules of behavior deducted from not following the internal procedure first. And it's also what the Council of Europe actually says, that when it comes to the hierarchy, there may be given consideration when deciding on remedies or levels of protection when a person has not followed the normal path, internal first. The EU, and it's one of the strengths, I think, of the directive, doesn't say you need to do the internal channel. It's encouraged. But if you don't, you will not lose the protection at all. You can go directly to the external, and there's limited scope, it's very precise article of when you can go directly to the media, to the public at large, or to journalists. It's also provided. Public disclosure is possible under certain conditions. So the ambiguity that we still had in the jurisprudence of the court in Strasbourg and in the recommendation in the 29 principles is actually, I think, solved at an EU level, because there's much more clarity, much more scope to go directly external and even to go to the public. I'm coming to a conclusion within the time limits, chairs. Follow-up and feedback. Follow-up is... Non-follow-up is probably the most important reason why people do not blow the whistle. In addition, there's also retaliation, of course. But the idea that nothing would happen with the information is the worst situation that you can imagine. So it's super important, it's also what the Council of Europe says, is that there is proper follow-up. The EU is simply harder and more detailed in what it actually means to follow up. It provides clear deadlines for the entities, both private entities and public entities, who must acknowledge receipt within 7 days, who must diligently follow up and also provide feedback to the whistleblower. Within 3 months, extendable to 6 months. It's mandatory, and if that hasn't happened, you definitely have the right to move on to external or immediately public. So it's hard rules. Confidentiality and rights of the persons concerned. It's an interesting topic. How does it bind? What's the relationship between both? I think the Council of Europe is sort of, again, not unambiguously clear about the relationship. It says, yes, confidentiality of ideas is important, but it needs to be balanced with fair trial rights. How balanced? How do you do that? Because they're opposed. The EU is more clear. The EU says no disclosure of ideas. But in the case when there is another person affected, you will need to disclose it. And then you need to be clear vis-à-vis the whistleblower that you will disclose, and you need to provide in writing that you will do so. So actually the fair trial rights are more clearly articulated and confirmed. And I think, and this is the only document that I know of, is this EU directive where it clearly says that also the persons affected or the one that the whistleblower has been blowing the whistle about, they are also protected in their rights officially in the text in a binding fashion. So if you read it at the bottom, effective remedy, fair trial, presumption of innocence, rights of defense, right to be heard, right to access the file, these rights accrue to the person which has been put on the radar by the whistleblower. So it's not just unambiguously phrased next to one another. It's not a juxtaposition of the protection of the idea versus some fair trial rights for the other person. No, it's in principle protection of the idea, including in the reporting and the follow-up. But then, when disclosure is necessary, it will need to happen for fair trial rights. And these fair trial rights are actually quite rich a set of rights. So I like that. Protection against retaliation, last 2 minutes. Chair, all soft documents are telling us that we need to protect against retaliation. What the EU does is repeat this, obviously, but come with an extremely broad definition of possible retaliation measures. I find it quite impressive. It's good. It's well done. It's broad. Why? Because it also extends to outside the work context. So if you start to blame a whistleblower on social media, not work connected, it's also retaliation, possibly. No other document has done that, so it's not bad. It's officially also inclusive of attempts or threats, not just the retaliation itself. Not the fact that someone is sacked, but the threat that you may be sacked is enough, okay? Or an attempt to do so. It also applies, and I find this spectacular, it's only a few words, not if an employer does so, but if an employer allows it to happen, or encourages it, or simply tolerates it, it triggers liability. Liability because there's also a sanctioning mechanism, not necessarily using the penal law, it can be civil law or administrative law, but any form of retaliation which is simply tolerated by an employer, public or private, will trigger sanctions. So it's hard. By the way, not only for retaliation sanctions, but also for hindering of reporting, or for bringing vexatious proceedings, or for breaching ID confidentiality. So it's I think, going further than anything that we've seen. Finally, to conclude, the mala fide, bona fide thing, there's been a lot of talk today about good faith. What is good faith? We've already tackled the way the Council of Europe is looking onto the matter. Council of Europe says you need to have like at least reasonable grounds to believe in the accuracy, but it doesn't say that you need to be bona fide necessarily. The EU is even strong, in a stronger fashion, saying that the EU says even if you're mala fide, it's okay if you have reasonable grounds that it's accurate. If you have a personal issue or personal grievance, but it's accurate, you can still be legible as a whistleblower. So it's much more precise. It's not as if good faith means that you cannot have any ulterior motives. Ulterior motives, negative motives, do not necessarily take away your legibility as a whistleblower. So again, this is I think a strong thing, and the protection against all forms of secrecy obligations was well explained already by Fabio, where the Court of Appeal said that in principle, at least, the offense is directly linked to the secrecy that they need to be waived. The Cour de Cassation went further. Actually, according to the EU text, it was rightly said the theft and the information fraud, they can still remain as official offenses because this was the illegal fashion in which the information was obtained. I personally find that defendable because what we haven't had, and I'll conclude here, in this entire EU initiative is any linkage to the sphere of informers or collaborators with justice. It's even clear that it's the last line of the last slide in the EU directive. It's quite explicitly said what we're creating here in this directive has nothing to do with informers. Informers, we also protect them. We also would grant them procedural anonymity, but we would also reward them. We're not talking about a reward-based whistleblowing system. Whistleblowing in this EU directive is separate from informers whom we pay, John's second category, or category 2A, John, and your category 2B, if I may, the collaborators with justice that would be given immunity or any other sort of advantage are also not within scope. it's of course, the member states are free to develop these. And with my institute back in, I think, 2005, we drafted 3 framework decisions for the European Commission on procedural protection of witnesses, on collaborators with justice, and on witness protection in general. None of them were accepted because before Lisbon we didn't have any competence to sort of adopt them in the sphere of procedural criminal law. But it's definitely not with this instrument that the linkage is made to the protection of witnesses who will get benefits in return for their disclosure. This is not within scope with which it is not said that member states can't do it. But so far the EU has not officially taken a stand on the issue, which perhaps is something to be pitied. On the other hand, it's quite impressive a document, I think, within the competencies that the EU has so far. Is that within the time? More or less.